Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. Today's question is another in our series entitled Real Estate Fundamentals You Should Know. Today's question goes like this. I'm the listing broker and I'm related to the seller. Do I have to disclose that I'm related to the seller? And of course, the relationship varies depending on the question that's asked, and I don't really care for the purposes of this question, but just assume it's a familial relationship. Do I have to make that disclosure? And the answer under Washington law is no. And the reason I'm distinguishing Washington law is because I'm going to give you a different answer under the Realtor Code of Ethics. But under Washington law, you don't have to make that disclosure. The Washington agency law creates a bias by broker in favor of the client that broker represents. Said differently, the agency law presumes that you are biased in favor of the party you represent. And whether that bias is based on agency law or based on a familial relationship does not really matter, because the agency law lets the party on the other side of the transaction know that you're looking out for your client's interests. That said, if you happen to be related, familially or otherwise, to the party on the other side of the transaction, then you would have to disclose that relationship. Because again, the agency law requires loyalty by you to the party that you represent. If you have a divided loyalty, because the agency law says you represent the seller as a listing broker, for example, but the buyer is related to you, your mother or your son or something like that, then you would have to disclose that familial relationship to the seller. You would have to disclose that conflict of interest and then proceed after disclosure of that conflict of interest in keeping with the seller's instructions regarding the ongoing nature of the relationship. Maybe the seller would want the designated broker to appoint another subagent of the firm to represent the seller's interest in this transaction, for example. If that happened, then as the former listing broker, you would still have to preserve the seller's confidences that you learned about the seller during the term of your agency relationship with the seller, but that might be one way that a seller would choose to resolve that conflict. Maybe the seller wouldn't have any problem with the conflict at all, but the fact that you disclosed the conflict is important and in fact critical, and therefore critical that you make note of it in your transaction file to preserve going forward so that you can prove that. Now, how is that different under the Code of Ethics? I don't know, because I'm the hotline lawyer. I don't interpret or enforce the Realtor Code of Ethics. The interpretation and enforcement of the Realtor Code of Ethics is reserved to each of the local Realtor associations. If you are in this position, though, where you are representing somebody related to you, you need to contact your local Realtor association, because I think you will find this is a relationship you have to disclose. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtor member.